Hello, everyone. Welcome, and thank you very much for joining us today for our presentation on Is EDI Still Legal in Canada? My name is David Wong, and I'm a partner in our Labour Employment Human Rights Practice Group in Vancouver, the co-leader of our national LEHR group, and the leader of our national human rights group. Before I introduce the other speakers, I'd like to draw your attention to the survey and CPD certificate points outlined on your screen. QR codes and links will be available at the end of the event to fill in our survey and to obtain your Ontario, Quebec, or BC CPD certificate. We'd appreciate it if you could take a minute to fill out our survey as well. My co-presenters today are Gillian, a partner in our Toronto office, and Brooke, Naomi, Levy, an associate in our Montreal office. Gillian maintains a broad labour, employment, and human rights practice. She regularly advises provincial and federal sector employees on matters related to employment standards, employment-related litigation, grievance arbitration, labour relations, and human rights. Brooke practices in all aspects of employment law, including matters relating to hiring, termination of employment, human rights and freedoms, and the application of federal and provincial employment labour standards. She has a particular interest in issues concerning executive employment agreements and equity-based compensation plans, as well as the interpretation of non-competition and non-solicitation covenants. With that, we'll get into our overview for today. The context of the bigger question is DEI still legal in Canada? We're going to start with a discussion about the U.S. Supreme Court decision in Students for Fair Admissions at Harvard and the approach that's being taken to DEI by the White House in the U.S. We'll talk about the issue, the meaning of equality, systemic discrimination, and stereotyping, and discrimination exemptions and special programs, all in the same context of answering that bigger question. So to start with the decision in Students for Fair Admissions in Harvard, and I'll start, as a lawyer, I would be remiss if I didn't start this discussion with my own legal disclaimer that I'm not an expert in American law. So I'm providing my summary of this decision without that expertise and only as I understand it. Here, Harvard and the University of North Carolina considered race in their admissions processes. In Harvard's approach, race was a, quote, determinative tip for a significant percentage of all admitted African American and Hispanic applicants. At UNC, applicants could receive a, quote, substantial plus depending on their race. Students for Fair Admissions is a nonprofit organization whose stated purpose is to defend human and civil rights secured by law, including the right of individuals to equal protection under the law. They filed a petition arguing that race-based admissions programs violate the Civil Rights Act and the 14th Amendment. The 14th Amendment Equal Protection Clause provided that no state shall deny to any person the equal protections of the laws, and that all persons, whether colored or white, shall stand equal before the laws of the states. The lower courts had found that the programs were permissible. A majority of the U.S. Supreme Court found both the programs violated the 14th Amendment Equal Protection Clause. They explained that eliminating racial discrimination means eliminating all of it. The Equal Protection Clause applies without regard to any difference of race, of color, or of nationality. It's universal in its application. In other words, equality is the same for all, regardless of historical context or disadvantage. Any exceptions must survive strict scrutiny, which asks whether the racial classification is used to further compelling governmental interests and whether the government's use of race is narrowly tailored, in other words, necessary to achieve the interest. Exceptions are rare because distinctions between citizens solely because of their ancestry are by their very nature odious to a free people whose institutions are founded upon the doctrine of equality. The majority referred to a decision of the U.S. Supreme Court that had been issued 20 years prior in Grutter and Bollinger, where the court had found that student body diversity is a compelling state interest that can justify the use of race in university admissions, but that expressed an expectation that in 25 years, the use of racial preferences would no longer be necessary to further the interest. The majority held that race-based admission programs were not sufficiently measurable to permit judicial review, that the interests including training future leaders, acquiring new knowledge based on diverse outlooks, promoting a robust marketplace of ideas, and preparing engaged and productive citizens cannot be measured. The programs fail to articulate a meaningful connection between the means they employ and the goals they pursue, and that the racial categories are plainly overbroad, for example, Asian, arbitrary or undefined, for example, Hispanic, or under-inclusive, as there was no category for Middle Eastern students, for example. Race-based admission programs are also found to fail to comply with the requirements that race may never be used as a negative and that it may not operate as a stereotype. Harvard's consideration of race had resulted in fewer admissions of Asian American students, such that race was used to advantage some at the expense of others. And admission programs required stereotyping, engaging in offensive and demeaning assumptions that students of a particular race, because of their race, think alike. The majority explained that race-based admissions programs lacked a logical endpoint, and that race-based admissions programs could not be reconciled with the guarantees of the 14th Amendment Equal Protection Clause. They did explain that nothing prohibited the universities from considering an applicant's discussion of how race affected the applicant's life, so long as that discussion is correctly or concretely tied to a quality of correct character or unique ability that the particular applicant can contribute to the university. So there's a lot in there, and obviously just covering it generally, but it frames the discussion that we're going to now have about Canada, and provides some very interesting points for comparison and contrast between the approach of Canadian courts and Canadian human rights tribunals to these types of issues. Before we get there, I'll just note that based on that decision in large part, the White House issued an executive order on January 22nd, 2025, which references terminating diversity, equity, and inclusion discrimination, mandating practices required to comply with the Students for Fair Admissions and Harvard decision, and faithfully advancing the Constitution's promise of colorblind equality before the law. So how does all of this compare to the law in Canada? We'll start that discussion with Gillian addressing the question of whether organizations in Canada are required to implement DEI. Gillian?
Good afternoon, everyone. So as David said, with recent changes south of the border, the question keeps being raised whether or not Canadian organizations are required or permitted to implement DEI initiatives. And the general answer to that question is that with some exceptions, such as for federally regulated employers, there are actually relatively limited express legislative requirements in Canada to implement DEI. The federal sector is a bit unique in that there are a few pieces of proactive legislation intended to advance equality, which includes the Employment Equity Act, the Accessible Canada Act, and the Pay Equity Act. But these statutes are limited in their application in that they only apply to federally regulated industries such as banks, airlines, railways. So while many organizations are not subject to mandatory DEI initiatives, there is legislation in most jurisdictions across Canada that permit voluntary DEI initiatives, and we'll review some of these pieces of legislation shortly. So Canada's legal interpretation of equality is different from that articulated by the US Supreme Court in the Harvard and UNC case. Canada's legal interpretation of the concept of equality largely comes out of Supreme Court of Canada case law interpreting Section 15 of the Charter, and then cases among the provincial or federal human rights commissions also discuss the concept of equality. So, as I said, Section 15 of the Charter is the main piece of legislation dealing with equality rights at the federal level. And Section 15 applies to government action in the form of legislation, regulations, directions, policies, programs, activities, and the actions of government agents. So the focus of Section 15.1 of the Charter is on preventing governments from making distinctions based on enumerated or analogous grounds that have the effect of perpetuating disadvantage or prejudice or imposing disadvantage on the basis of stereotyping. And then the focus of Section 15.2 of the Charter is actually on enabling governments to proactively combat discrimination. So the Supreme Court of Canada has consistently characterized the guarantee of equality under Section 15 of the Charter as substantive rather than formal. So formal equality is what the US Supreme Court essentially talked about in the UNC and the Harvard case. Formal equality refers to treating everyone the same, versus substantive equality, which actually recognizes that mitigating the effects of historical disadvantage based on discrimination requires treating some people differently. And it can actually include things like taking steps to implement special programs or special measures to ensure that historically disadvantaged groups have equal opportunities. The Supreme Court has actually found that formal equality ignores historical and ongoing barriers, and it can actually perpetuate inequality for certain groups. So RV Cap is one of the Supreme Court's landmark cases on equality rights under the Charter. So in this case, a group of mostly non-Indigenous commercial fishers challenged certain licenses under the federal Aboriginal fisheries strategy. And these licenses gave special privileges to 3 bands and designated a 24-hour period of sole access to the river. The applicants argued that these exclusive fishing licenses granted to the 3 bands discriminated against non-Indigenous commercial fishers on the basis of race. The Supreme Court of Canada disagreed. So what they found was that these communal licenses were actually valid ameliorative programs under Section 15.2 of the Charter. And the program was specifically intended to address the disadvantage of Indigenous peoples in fishing who had historically been excluded from the industry. The Supreme Court emphasized that programs that are actually aimed at rectifying or mitigating historical disadvantage or discrimination are not necessarily discriminatory under Section 15.1 of the Charter, and they can be justified under Section 15.2. And the basic purpose of Section 15.2 of the Charter is to shield ameliorative programs from the charge of reverse discrimination. Section 15.2 also enables the government to combat discrimination through programs aimed at helping disadvantaged groups without fear of challenge under Section 15.1 by groups that don't share that disadvantage. And it also allows the government to assist one disadvantaged group without necessarily being paralyzed by having to assist all disadvantaged groups at the same time. And then Fraser versus Canada is actually a more recent case, and it's another example of the Supreme Court of Canada's view of substantive equality in respect of employment decisions. So in this case, the 3 claimants were RCMP officers who had children in the 1990s. They all returned back to work and they found it hard to juggle balance and childcare responsibilities. And at that time, the RCMP wouldn't allow part-time employment. So all 3 of them, 1 retired and 2 went on unpaid leaves of absence for significant periods of time. Later in the 90s, in 1997, the RCMP actually began to provide a job sharing program as an option instead of unpaid leaves. So essentially 2 or 3 individuals could share a full-time role, which actually benefited both the employees as well as the RCMP. So the 3 claimants actually returned back to work at the RCMP and joined the job sharing program. Now, under the job sharing program, understandably, a lot of people who joined the program were women with children, and most of them actually joined the program to balance their childcare responsibilities with their work. RCMP employees have a pension plan, and under the pension plan, full-time members could buy back pension credit if they were suspended from duty or they took unpaid leaves. But this pension buyback was not available to people under the job sharing program. And ultimately, this meant that full-time employees could actually have a greater pension entitlement at retirement because they were able to buy back that credit, whereas people in the job sharing program weren't permitted to do so. So the claimants challenged the adverse pension consequences of the job sharing program, and they claimed that it breached their equality rights under Section 15 of the Charter. They argued that it treated job sharers, that the pension plan requirements treated job sharers worse than other members of the RCMP, and particularly individuals who are mostly women with children. The Supreme Court agreed with the claimants, and they re-articulated the principle that laws that may seem neutral on their face can still discriminate against members of a protected group by affecting them differently. So the Charter protects certain groups that share specific characteristics, for example, race or religion. And the law isn't allowed to discriminate against people based on these protected characteristics. So to decide if equality rights have been breached under Section 15 of the Charter, the court first looks at whether or not a protected group is singled out by the law somehow. Members of the group don't have to show that the protected characteristic like race or age somehow caused the group to be more affected. And it also doesn't matter if all members of the group are affected in the same way. What the court noted is that many attitudes and policies had disadvantaged women in the past, and rules like those in the pension plan could actually build on or perpetuate historic disadvantage. So in this case, the Supreme Court found that the pension plan breached the job sharer's right to equality, and it was because it disadvantaged women more than men. And it didn't matter that the pension plan didn't specifically set out to hurt women in particular. What mattered was the effect of the pension plan. So as I said, the job sharers were mostly women who were job sharing because they needed to care for their children. And the pension plan maintained the disadvantage caused by the long-standing expectation that women should be primarily responsible for child-caring activities. And so with that, the majority said that the job sharers should be permitted to buy back their full pension credits. I will turn it over to Brooke for a discussion of the Quebec Charter.
So good afternoon, everyone. Before getting into the right to equality under the Quebec Charter, I think it's important to discuss some of the differences in the application of the Canadian Charter versus the Quebec Charter. So as Gillian just mentioned, the Canadian Charter applies to public bodies and does not apply to private individuals, businesses, and other organizations. It solely addresses government actions and public matters. In contrast, the Quebec Charter has a broader scope. It governs not only public bodies, including the Quebec government and its institutions, but also the private sector. This includes individuals, groups, organizations, private companies, and both public and private services. Now, in terms of the legal status, the Canadian Charter is part of the Constitution. This gives it a very high status in our legal framework. On the other hand, Quebec Charter is a provincial statute. This being said, the Supreme Court of Canada has acknowledged what's deemed as a quasi-constitutional status of the Quebec Charter, granting it supremacy over ordinary laws. So what does this mean? In essence, it means that the provisions of the Quebec Charter are considered an integral part of any law in Quebec, without needing to be explicitly mentioned within the law itself. Essentially, the guarantees offered by the Quebec Charter are part of the implicit content of all laws in Quebec. This supreme status is also codified in the law in Section 52. This section grants the Charter supremacy over all laws in Quebec, regardless of their date of enactment. Therefore, all laws adopted in Quebec must be interpreted in accordance with the Quebec Charter. Now, despite Quebec having its own charter, it is recognized that the charter must be interpreted in light of the Canadian Charter, as well as other prevailing human rights legislation. So just like the laws from which it was inspired, the Quebec Charter essentially aims to ensure the protection of the right to dignity and equality of every human being. This being said, the right to equality does not necessarily imply identical treatment, as Gillian mentioned. In fact, different treatment may be necessary to promote equality. So what is protected by the Charter is not formal equality, but rather real substantive equality between individuals. In Quebec, it's our Section 10 of the Charter, which is the key provision regarding equality. This is similar in nature to the Canadian Charter's Section 15. However, the right to equality in the recognition and exercise of all human rights and freedoms is not simply limited to Section 10. It's actually set across multiple articles or multiple sections, being sections 10 to 20.1. Now, as I mentioned, both Section 15 and Section 10 guarantee equality rights and aim to protect against discrimination. However, there are still notable differences between their scope and their application. Unlike Section 15 of the Canadian Charter, which creates an autonomous right to equality before and under the law, Section 10 focuses on equality in the recognition and exercise of rights listed in the Quebec Charter. As illustrated in the previous slide where Section 10, this guarantees equal recognition and exercise of human rights and freedoms without discrimination based on various grounds, including race, color, sex, gender identity, and others. While these grounds are to be interpreted in a large and liberal manner, it's an exhaustive list. This is different than the Canadian Charter. Under Section 15 of the Canadian Charter, discrimination occurs when an individual or group is treated differently based on an enumerated or analogous ground. This aligns with what I previously said about the Charter creating an autonomous right to equality. In this sense, discrimination under the Canadian Charter can occur in two ways, either explicitly through an enumerated ground or adversely through an analogous ground, where that differential treatment indirectly reinforces or perpetuates a disadvantage for a group that is not explicitly listed, but is recognized and warrants protection under the law. In Quebec, the courts have confirmed that Section 10 of the Quebec Charter does not recognize analogous grounds for discrimination. This means that unlike the Canadian Charter, Section 10 requires proof of specific elements such as distinction, exclusion, or preference based on an enumerated ground which is listed in our Section 10. There is a three-step test which must be followed to establish a complaint for discrimination under Section 10. So as I mentioned, there must be an action, policy, or law that creates a distinction, exclusion, or preference. This distinction, exclusion, or preference must then be based on one of the enumerated grounds listed in Section 10. And lastly, the action, policy, or law must have the effect of nullifying or impairing the right to full equality in recognition and exercise of another human right or freedom protected by the Quebec Charter. So unlike the Canadian Charter, the Quebec Charter does not protect the right to equality in itself. This right is only protected in the exercise of other rights and freedoms which are guaranteed by the Charter. This distinction between the two charters is crucial because the right to equality is not standalone, but is instead intertwined with other rights and freedoms. This is why the third element of the test requires the identification of a specific right or freedom for which the person has been a victim of discrimination. This approach ensures that the claim is directly linked to an infringement of another protected right or freedom, which provides for a more clear and structured framework. It's also important to note that claims under Section 10 do not require proof that the discrimination perpetuates a disadvantage based on a prejudice or stereotype. Instead, the focus is on whether the personal characteristic recognized as a prohibited ground of discrimination under the Charter contributed in some way to the alleged act. This differs from the analysis provided for in Section 15 of the Canadian Charter. So an example of how to look at the discrimination analysis framework in Quebec, I'd like to bring your attention to this decision. In this decision, there was an employee who was forbidden from working on Saturday because his employer had implemented a new policy whereby Jewish employees were prohibited from working on the Sabbath. In this instance, the tribunal examined the facts and analyzed whether forbidding the employee to work on Saturdays because of his religion, because he was Jewish, violated his right to equal and non-discriminatory treatment in employment based on his religious grounds. The tribunal concluded that forbidding the employee to work on Saturdays simply because he was Jewish did in fact violate his right to equality in employment, in addition to his freedom of religion, in addition to his dignity and privacy. So in its analysis, not only did they find that it was discriminatory, but they linked this discrimination to other grounds which are protected under the Act. So it doesn't necessarily need to be one. As you can see in this instance, there was multiple grounds which were determined to be in violation. I'll now pass it on to my colleagues to continue.
Thanks, Brooke. So at this stage, with the explanations there from Gillian and Brooke of the approach in Canada to the concept of equality and my initial discussion around the U.S. Supreme Court decision, I think you'll probably be getting a sense of the difference and one of the key significant differences in the two countries as it relates to, well, we'll get to the DEI program and bringing it together, but in terms of the reasoning of the U.S. Supreme Court, the difference that the courts up here in Canada take to that issue and how significant it is. So in the context of this discussion, we're now going to move on to talk a little bit about systemic discrimination and stereotyping and the approach, again, that the Canadian courts and tribunals take to these issues, again, having heard how the U.S. Supreme Court approached them in the Harvard case. The first decision is a decision of the Human Rights Tribunal in British Columbia, Campbell and Vancouver Police Board. And this was a case, the human rights complaint from an Indigenous mother against police relating to interactions in the arrest of her son. The mother was out for a walk and happened to witness a police stop involving her son. And she was obviously concerned and was roughly and physically separated from her son by the police and blocked from witnessing his arrest. In the context of this incident, there were no comments made by the police relating to her race, color, or ancestry. So there was nothing direct as it relates to discrimination, no comments, no direct connection between what the police did, how they acted, and the complainant's race. But the tribunal, in considering the complaint, considered the social context that framed the interaction, which they explained was colonialism and historical trauma. And with that context, the tribunal held that the police had misunderstood the mother and why she was concerned and treated her conduct as suspicious. It also noted that the police lacked training and awareness of the impact of colonialism and historical trauma on Indigenous people and how that could impact the response of Indigenous people to their actions as police officers. Ultimately, the tribunal found that the police officer's reaction to the mother was not proportionate and had the effect of perpetuating historical disadvantage, and therefore finding it was systemic discrimination and a violation of the BC Human Rights Code. Now, how does this decision, obviously an individual human rights complaint, relate to our discussion? Well, I think you can see from this decision, the tribunal's approach to systemic discrimination stands in contrast to the approach of the U.S. Supreme Court to equality that we talked about, and is more in line with the Canadian court's approach to substantive equality. Specifically, the tribunal approached the issue of whether the complainant had suffered discrimination by considering the historical context and disadvantage of Indigenous people, rather than finding that doing so is stereotyping itself, or that equality must be considered without regard to any differences of race, of color, or of nationality. The next decision I'm going to speak about relates to stereotyping, and it's another decision of the BC Human Rights Tribunal, this one in Mema and City of Nanaimo. Here, the complainant was a Black man who had been terminated from his employment following the issuing of a report conducted by a third party into corporate credit card use. The author of the report held a sincere belief that they were acting in line with their training and their principles. So again, not a situation where this individual was consciously or purposefully discriminating against the complainant. The report didn't contain express or intentional racial discrimination. However, the tribunal found that it was informed by racial stereotypes. And so the city, the employer in this case, had decided to terminate the employment of the complainant based on the report that had itself been informed by racial stereotypes. And again, even though nothing was purposeful, taking into consideration those racial stereotypes and the fact that the decision, again, not based on race, but based on this report that was informed by those stereotypes, was therefore discriminatory. So again, the tribunal's approach in this case stands in contrast to the approach of the U.S. Supreme Court, this time with respect to stereotypes specifically. The U.S. Supreme Court had found that to assume that to advantage members of a racial group would be to stereotype them as all having been subject to disadvantage. In contrast, in this case, the tribunal inferred that a stereotype relating to a racial group was a factor and a basis for a finding of discrimination against an individual member of that racial group, without the need for evidence of that individual having suffered historical disadvantage. The next case I'm going to discuss, it's a decision of the Supreme Court of Canada. You may have heard the summary of this one before. It's been around now since 2017. Again, relating to stereotyping, but a bit of a different approach that was taken here. In this case, the employer had in place a policy that required employees to disclose in advance of any incident at work that they suffered from addiction. The complainant was involved in an accident at work and tested positive for drugs and claimed at that point that they suffered from an addiction. They filed a human rights complaint that went to the Alberta Human Rights Tribunal, which concluded that the reason for terminating the employee was not the addiction, but was the breach of policy by the employee. The tribunal found that the employee had capacity to comply with the terms of the policy. And so it wasn't that they were addicted, that they had an addiction, despite the fact that the termination related to an incident where they had been using drugs, but the fact that they hadn't complied with the policy and there wasn't anything that stopped them from complying with the policy, and that was the reason for the termination. The tribunal held that the employee would have been terminated whether they were an addict or a casual user of drugs. The Supreme Court of Canada noted that it cannot be assumed that employees' addictions diminished, that employee's addiction diminished his ability to comply with the policy. In some cases, a person with addiction may be fully capable of complying with workplace rules, and in others, the addiction may effectively deprive a person of the capacity to comply, and the breach will be inextricably connected with the addiction. But that each assessment must be done on a case-by-case basis. So, unlike the prior two cases that I discussed, this case is more aligned with the approach of the U.S. Supreme Court to the issue of stereotyping. Specifically, the court here was not willing to stereotype all people with addiction as suffering from the same symptoms, and acknowledge that in cases like this, each individual circumstance has to be considered. However, I do note that, unlike the decision of the U.S. Supreme Court, this case was not a decision relating to a special DEI program aimed at ameliorating disadvantage, but was a question of whether there had been discrimination against one specific individual. Shifting gears now, we're now going to talk about special programs, exemptions, and permissible discrimination. And what we mean by special programs, they are essentially programs aimed at increasing diversity and or reducing disadvantage of historically disadvantaged groups. So in other words, programs which are often referred to as DEI. There is, well, as a starting point, now those programs do, by their very definition, discriminate in favor of certain groups. But as Gillian, I think, mentioned at the start there are legislative exemptions that provide that in certain circumstances, those programs do not violate human rights protection. So this topic now, we're talking about these special programs. The Harvard and UNC application programs would fit within special program discussions. So we're sort of more now directly on point talking about programs like the ones that were considered by the US Supreme Court. So to start with, legislatively, we've got a table here that shows the jurisdictions in Canada and whether their legislation relating to human rights or equity provides for a special program exemption. And you can see there, the answer is yes for every jurisdiction. Now, there's different ways that those programs can be exempted and different options available. You'll see that one category there, pre-approval available. So you'll see in some jurisdictions, you can actually go in advance to have the program approved. So it's found and held not to be discriminatory before you implement it, whereas others, you don't have that option. And it's going to be, if it's challenged, you'll be able to rely on the provisions of the Act to try and defend it as not being discriminatory. So I'm going to first speak about the special programs exemptions in BC. That exemption is provided under Section 42 of the BC Human Rights Code, where 42.1 provides it's not discrimination or contravention of this code to plan, advertise, adopt, or implement an employment equity program that A, has as its objective the amelioration of conditions of disadvantaged individuals or groups who are disadvantaged because of Indigenous identity, race, color, ancestry, place of origin, physical or mental disability, sex, sexual orientation or gender identity or expression, and B, achieves or is reasonably likely to achieve that objective. So this exemption under section sub 1, there's a couple of points to note. First, it's specifically for employment equity programs. So it's limited in terms of scope in that way. It's not broadly to any special program. So for example, the Harvard and UNC application programs would not likely fall within the definition of an employment equity program, and so would not likely be covered by this exemption. There's no reference to or ability for pre-approval, as you can see in this section. So the question, this would serve as a defense if there was a complaint filed. You'd be able to rely upon this section, but there wouldn't be pre-approval that you could have. You'd need to meet those two, the two criteria though, to be able to meet the exemption. And it has as its objective the amelioration of conditions of disadvantage for individuals or groups. And then also achieves or is reasonably likely to achieve that objective. So based on the face of that language, it seems that it's not a simple test in terms of achieves or reasonably likely to achieve. You'd still need to convince the tribunal that objective is met by that program. The second exemption under the BC legislation is for special programs more generally, and section 42 sub 3 provides on application by any person with or without notice to any other person, the commissioner may approve any program or activity that has as objective the amelioration of conditions of disadvantaged individuals or groups. And then sub 4, any program or activity approved under subsection 3 is not in contravention of this code. So unlike the first exemption, this is not limited to employment equity programs. It's for any program or activity that has as its objective the amelioration of conditions of disadvantaged individuals or groups. So again, going back to the Harvard and UNC example, this would be, they would fit within that. But at least on the face of the language, you see, it says on application by any person. So there is, at least on its face again, a requirement to apply to the commissioner for approval of a program. And if you get that approval, then it is not discrimination under the code for that program. So if someone were to challenge the program, the defense would be relatively straightforward in that the program's already been approved and it's not a violation of the code. I will give a bit of a spoiler in terms of a decision I'll be speaking about next. That language that seems pretty clear on application by any person, the courts have interpreted it in a somewhat surprising but somewhat helpful way for those organizations that do want to implement DEI programs. So before I get there, though, just on the special programs applications. So the process for those applications is an application to the BC Human Rights Commissioner, and that's a separate entity from our BC Human Rights Tribunal, which decides human rights complaints. The Commissioner is a separate entity, and you file your application with the Commissioner, and they will consider and approve programs where they're satisfied that they meet the tests under 42 sub 3. The application forms themselves are somewhat informative in terms of what these programs need to look like in order to meet that exemption. The application form requires a description of the special program, including the individuals or groups the program will target, the proposed eligibility criteria for the program, including how membership in a target group will be assessed, the anticipated time frame for the program, including the requested duration of the special program approval, which is typically for 5 years with an option to renew. The form also has a section for the purpose of the special program, which describing the disadvantage that the special program is intended to address, how the special program is designed to address the disadvantage, the anticipated benefits of the special program, and how success is defined. And finally, the forms also include a section for accountability and monitoring, describing how the special program will be monitored on an ongoing basis, the specific metrics that will be used to measure program outputs and outcome. So reflecting back to the US Supreme Court decision, what's required in these applications is somewhat interesting, as many of the areas that need to be addressed in the special program applications are those that the US Supreme Court found to have not been appropriately addressed in the admissions policies of Harvard and UNC, and were bases for the finding that they were illegal. Now, I'm going to talk about this decision, which it's a decision of the BC Court of Appeal from 2022, which is significant. It's a significant one for the purposes of this discussion and the question of whether DEI is still legal in Canada, or BC at least. Here, despite the language of Section 42 of the Human Rights Code, which I just went over, the decision of the BC Court of Appeal is informative of how the tribunal and courts here apply the exemption under the code for diversity programs. So before I get into the facts of this case, just as a starting point, I note in a decision from 2000, the tribunal had held, the BC Human Rights Tribunal had held that exemptions to human rights legislation, so those under Section 42, are to be interpreted narrowly, and the burden of establishing an exemption is on the party seeking to rely on it. That was the law, that was the explanation from the tribunal back in 2000 in terms of how they were going to apply these exemptions, which, again, is a little bit more aligned with the US Supreme Court in terms of how they were looking at these issues. Now, as you'll see as we go through this decision, it appears that that approach has changed. So the facts of this case here, the union had offered enrollment preference for writing workshop to Indigenous, LGBTQ+ and diverse members. That's how they had framed it. A program that would generally be referred to as a DEI initiative or DEI program. The complainant in this case identified herself as a heterosexual woman who is biracial, but has been told she does not look ethnic enough to be considered diverse. She alleged that the union had discriminated against her based on her sexual orientation and ancestry, and that the union had decided that heterosexual women deserve less support than ethnic minorities and LGBTQ members. The complainant argued she had been unfairly pushed aside and kept from working for years due to the union's preference for diverse and LGBTQ plus members, and that the interest of diverse and LGBTQ plus members who do not actually face barriers in the arts have prevailed over her own because those members have a stronger lobby group. The union was not the employer in this case, so the training they were giving didn't fit within the employment equity program definition, and so wasn't exempted under Section 42 sub 1 of the Human Rights Code. And the union had not sought pre-approval of the special program under Section 42 sub 3 of the Human Rights Code. So the complainant argued Section 42, the exemptions in the code, didn't apply to provide the union a defense to the complaint in establishing this program. The Human Rights Tribunal at first instance held that while special program approval pursuant to Section 42 may engender peace of mind, it's not always necessary to avoid a finding of discrimination. A program which ameliorates disadvantage and does not adversely impact other groups in a way that triggers the code's protections does not violate the code. For example, programs that create opportunities for Indigenous people will not violate the code, whether or not they are specifically approved under Section 42. Such efforts are a necessary part of the work to remedy the past and present effects of colonialism and historical trauma inflicted on Indigenous people in Canada. So that preview that I gave there, the tribunal's root finding was that despite the fact that that language in 42 sub 3 for special programs on its face says on application, where there's an application being made, the tribunal was willing to apply that exemption under Section 42 sub 3 to what I'll call DEI initiatives, to this DEI program, without there actually having been an application having been made and approval having been granted by the BC Human Rights Commission. The BC Court of Appeal explained that the concept of substantive equality lies at the heart of the code's anti-discrimination purpose, and recognized that not every difference in treatment between individuals produces inequality. So you've heard a lot already about that substantive equality and the difference between that approach in Canada and that in the US, but I think especially in the context of this decision, which is directly on point, it's particularly notable. On the contrary, ameliorating disadvantage and achieving substantive equality may require accommodating differences. In particular, a program that distinguishes between individuals based on a protected ground to ameliorate the conditions of a disadvantaged group furthers substantive equality and is not discriminatory, even though such programs necessarily exclude people from other groups. This is because differential treatment in the service of equality for disadvantaged groups is an expression of equality, not an exception that requires exemption. In the result, the Court of Appeal rejected the argument that a special program must receive pre-approval under Section 42 of the Human Rights Code to be non-discriminatory. So the Court of Appeal in BC upheld that tribunal's approach, that even though the language of Section 42 sub 3 specifically speaks to approval, no approval is actually necessary to meet that exemption. The court also rejected that respondents need to prove the presence of discrimination against those individuals with code-protected characteristics in order to justify the program. The court instead recognized that disadvantaged groups are identifiable by their protected characteristics, which connote vulnerability, prejudice, and negative social characterization, and that not all members of the group need to be disadvantaged as long as the group as a whole has experienced discrimination. So this decision of the BC Court of Appeal is the most directly applicable to the question of whether DEI is still legal in Canada and stands in stark contrast to the US Supreme Court decision. Specifically, in contrast to the approach of the US Supreme Court, BC Court of Appeal's approach finding the DEI program legal was to consider substantive equality and to take notice of the disadvantage suffered by a group without the need for disadvantage to have been suffered by each member without finding that was improper stereotyping. Unlike the U.S. Supreme Court, the BC Court of Appeal did not find that the special program illegal as a result of the inability to measure its effects. This decision should go some way in relieving concerns of organizations who have or wish to implement DEI initiatives in Canada, or at least in BC specifically, that may have been declared to be, or that they are concerned may be, illegal in the US. That any such bona fide initiatives aimed at benefiting traditionally disadvantaged groups will not be found to be in breach of the BC Human Rights Code and are thus still legal. The one thing I will say, though, with respect to the special program's approval process and application, as I said, this decision stands for the proposition that you don't necessarily have to make that application to be subject to that exemption. If you can, and if you do make that application in advance and you get that pre-approval, it will obviously make things a lot more straightforward in defending that program if it is challenged. You'll then have that pre-approval to rely upon, which may discourage a complaint in the first place. And if a complaint is brought, it should make a defensive one much more straightforward. So my advice would still be, despite the fact you may still be able to rely on the exemption, without the application and pre-approval, still take that step, get that pre-approval if you decide you want to have any of these programs in place. I'll now turn it over to Gillian to take us through the situation in Ontario.
Thanks, David. So similar to BC, Ontario's Human Rights Code allows for programs designed to help people who experience hardship, economic disadvantage, inequality, or discrimination. And like David said, this can be by way of special programs. The Ontario Human Rights Code also protects these programs from attack by people who don't experience the same disadvantage. So in other words, it protects from reverse discrimination claims. So the relevant section of the Ontario Human Rights Code is Section 14, which in effect states that it is not discrimination to put in place a program if it is designed to relieve hardship or economic disadvantage, help disadvantaged people or groups to achieve or try to achieve equal opportunity, or help eliminate discrimination. A program has to satisfy at least one of these points to be considered a special program under the code. And the purpose of Section 14 of the code is twofold. So the first is to protect affirmative action programs from challenge by people who don't experience disadvantage, as I said. And second, by promoting substantive equality to address disadvantage and discrimination. Unlike BC, as David was mentioning, it doesn't just apply to employment, it applies to the provision of services, housing, etc. So there are many types of programs that could qualify as a special program in Ontario. So under Section 14 of the 14.2 of the Ontario Human Rights Code, an organization can apply to the Commission for a designation of a program as a special program. It is not a requirement in Ontario. It is a voluntary process that organizations can go through. The Ontario Human Rights Commission actually has a guide to special programs under the Human Rights Code, and it helps organizations understand the criteria for special programs, as well as a checklist that organizations can follow and review when creating a special program or determining whether they want to create a special program. So if an organization does decide to apply for pre-approval of a special program to the commission can either designate a special program if it meets the requirements, or it can request modifications to the program and then designate the program. So as I mentioned, Ontario does not require pre-approval, but again, it can help in the event of a legal challenge. So the pre-approval process under the code requires you to apply to the commission, and similar to what David referenced in respect of BC, the commission is distinguishable from the Human Rights Tribunal. The tribunal decides human rights complaints, whereas the commission is an independent body. So you apply to the commission can designate the program, it can accept the program as is, or it can require modifications to the program before providing the designation. Independently, the commission can actually initiate inquiries on its own. It's very rare, and they can actually designate a program as a special program on its own initiative. Designations expire 5 years after they're issued, and applications for renewal of a program must be made before expiry, and the commission can renew the program if it continues to meet the requirements of a special program. And the effect of a designation, as I said, it serves as proof that a program is a special program for legal purposes. And if the commission actually refuses to designate, it can serve as proof that the program is not a special program. And again, a designation under Section 14 can serve as a defense if the program is challenged at the Human Rights Tribunal. So there's been a few recent cases from the Ontario Human Rights Tribunal about special programs, which I think would be interesting to cover. So the first is this Lishk v. Ontario, specifically Ontario, the Minister of Education. So in this case, the father of a student alleged discrimination in the provision of educational services on the grounds of race and color. So the applicant alleged that a summer program that was offered to Black students in 2021 by a local school board, which was not available to white students, was discriminatory against non-Black students and amounted to a breach of the Ontario Human Rights Code. And similar to what was alleged in the UNC and Harvard case, they also alleged that the program was condescending towards Black students or stereotyped against Black students, essentially. The stated goal of this summer program was to admit promising Black grade 10 students and provide them with multi-year opportunities in leadership development, career exploration, responsible citizenship, and encouragement to serve their schools and community. The HRTO found that there was no question that this program met the criteria of being deemed a special program under Section 14 of the Human Rights Code. On my view of the case, it wasn't a pre-approved program. The Commission had not previously approved the program. The HRTO, they acknowledged the applicant's submissions that the program was condescending towards Black students, and they acknowledged the observation that many Black youth are highly successful in their education. However, that being said, the Commission's policy on racism and racial discrimination supports the allegations that many more Black students are disadvantaged and experience hardship in accessing equal educational opportunities as compared to non-racialized peers. The HRTO specifically said that a program that aims to provide equal opportunities to persons who are disadvantaged on the basis of a protected ground, such as color, race, or disability, can, without in any way breaching the code, limit its services to individuals who are identified by the prohibited ground, which in this instance was race and color. And then another somewhat recent case from the Human Rights Tribunal is KP and Little Native Hockey League. So this case was provision of services. It was a youth hockey league. So a 17-year-old Indigenous woman was denied membership in the LNHL on the basis that she was not a member of an Ontario First Nation. She was Indigenous. Both her mother and father were 100% Indigenous. In this case, the LNHL was established in the 1970s to provide Ontario First Nation children and youth with an opportunity to play hockey and come together with one another to celebrate and represent Ontario First Nation communities. any players that were admitted to the league had to provide proof of eligibility. So they must have valid certificate of Indian status from an Ontario First Nation, and there was no flexibility in this requirement. And so in this situation, while the young woman was Indigenous, she was not a member of an Ontario First Nation. So the applicant argued that the denial or denying her entry into this hockey league was discriminatory and amounted to a breach of the Ontario Human Rights Code, especially particularly because she was Indigenous. And the HRTO disagreed. They said the league was not a breach of the code and the league requirements were not a breach of the code. They said that Section 14 of the code is designed to protect from challenge programs that are established to relieve hardship or disadvantage that is faced or has been faced by individuals, such as was the case for First Nations youth in hockey in Ontario, who were historically denied the opportunity to play in other leagues. So again, it just goes back to the point that not everyone needs to be, who has historically experienced disadvantage needs to be treated the same. You are allowed to distinguish amongst historically disadvantaged groups, and special programs are allowed to do that as well. So special programs could advantage one disadvantaged group over the other. So next I'll briefly talk about the federal jurisdiction as well, and the Canadian Human Rights Act. So the Canadian Human Rights Act as well as the Employment Equity Act. So in the federal jurisdiction, special programs are actually addressed in two different pieces of legislation. As I said, the Employment Equity Act and the Canadian Human Rights Act. So the Employment Equity Act requires federally regulated employers with 100 or more employees to establish proactive employment practices, such as special measures in some cases, to address disadvantage and persistent gaps in representation of 4 designated groups. So it's actually women, Indigenous peoples, persons with disabilities, and visible minorities. Special measures and employment equity plans can include things like targeted recruitment, career development or training for designated group members, flexible work arrangements, and internal mentoring or networking. Special measures under the Employment Equity Act are similar to special programs, but they have additional legal requirements, and they must advance equality and address genuine disadvantage. And those measures are they're temporary in nature and they're legislative requirements. Whereas the Canadian Human Rights Act is permissive. So Section 16 of the Canadian Human Rights Act permits employers to voluntarily implement programs to prevent or reduce employment barriers. And I should also say that the Canadian Human Rights Tribunal actually has the authority under the Canadian Human Rights Act to order an organization to implement a special program to remedy discrimination if they find that the employer's conduct has been discriminatory. So the applicable section of the Canadian Human Rights Act is Section 16. And again, so Section 16(1) says that special programs designed to prevent, eliminate, or reduce disadvantages suffered by groups based on prohibited grounds are not considered discriminatory practices. Under Section 16(2), so there's not a pre-approval process under the federal statute, but the Canadian Human Rights Commission can provide recommendations, advice, and assistance, but they don't actually approve a program. Section 16(3) of the federal statute also says that collecting information related to prohibited grounds of discrimination is permissible if it's intended for the adoption or implementation of a special program. So special programs under the federal statute, it can be used in a wide range of contexts in employment and the provision of services. So, for example, it could include an employment program that's meant to provide opportunity for people with intellectual disabilities. It could include a policy for giving reduced airfare for remote communities, remote Inuit communities, or it could result in mentorship and leadership training programs for Black or Indigenous employees. And they're really quite broad in terms of the range of what special programs can be under the federal statute. And like I said, the Canadian Human Rights Commission has the discretion to give guidance on special programs, but they do not require approval to be in effect. And then an organization responsible for special programs under the Canadian Human Rights Act must be able to demonstrate that the program was designed to benefit or improve the situation of target group or groups. And the design or implementation must reflect a genuine intention to prevent, reduce, or eliminate identified disadvantage. Similar to the Ontario Human Rights Commission, the Canadian Human Rights Commission also has as guide on the development and implementation of special programs. It's quite detailed. It actually gives a lot of helpful information to organizations on how to develop special programs, how to monitor them, track them. So there are resources available as well to federally regulated organizations. And I will turn it over to Brooke to talk about Quebec.
So the system in Quebec in terms of similar types of programs is a bit different. And as I had mentioned before, all laws and regulations that are adopted in Quebec are aligned with or in support of the Canadian Charter. So in terms of discussing the types of programs available in Quebec, I think it's important to highlight the exemptions that are listed under the Charter, because it's those exemptions that are then reflected in our special programs. So as Gillian and David mentioned, the right to equality is not absolute. There are certain situations where exemptions are permitted. In Quebec, this means that certain individuals who contravene Section 10 of the Charter may be exempt from liability if they can demonstrate that the difference in treatment is justified. Depending on the circumstances, there are various exemptions and various defenses which are available. From an employment perspective, it's really sections 20 and 20.1, which are of interest. To determine whether there is an unlawful infringement of a right, the Quebec Charter provides a two-step approach. The first step is for the person who claims that they were a victim of a violation of a fundamental right to prove this violation. In Quebec, this proof is done on a balance of probabilities. The second step is that the person who committed the act then has to establish that the infringement of the right is justified and therefore lawful. Now, Section 20 of the Quebec Charter offers two defenses. The first part of Section 20 allows an employer to be exempt from liability by demonstrating that the differences in treatment complained of by the plaintiff are based on aptitudes or qualifications which are required for the job, or in other words, that it constitutes a bona fide occupational requirement. Now, according to the Supreme Court of Canada, from a discriminatory standard, the employer must be able to establish three things. One, that the standard was adopted for a purpose rationally connected to the performance of the work in question. Two, that the employer adopted the particular standard as it was necessary to achieve the legitimate work-related purposes. And three, that the standard is reasonably necessary to achieve the legitimate work purpose. So, in 1985, the Quebec Charter was amended. It was amended to insert Part 3, which is the section which concerns affirmative action programs. So special programs at the federal level or at the other provincial Canadian province level. In Quebec, these are deemed affirmative action programs. That would be the umbrella term. Inside the affirmative action programs, we have what's called equal access to employment programs, which I will discuss later on. But essentially, these affirmative action programs were intended or are intended to rectify the situation of groups that are victims of discrimination, and it provides specific measures that could be taken for their benefit. So subsequently, after the year of the adoption of this section, several types of affirmative action programs have been successfully adopted by the government. It's resulted in parallel initiatives which are unconnected but respond to different criteria. And this is different than the federal implementation of special programs. As David mentioned, diversity initiatives by definition discriminate in favor of certain groups, but the legislator has intentionally provided carve-outs to this discrimination under certain circumstances, such as the inclusion of such affirmative action programs. So as I mentioned, affirmative action programs can also be known as equal access to employment programs in Quebec. and these are specifically designed to counter systemic discrimination in employment. Now, while their objectives resemble those of the federal sector and other Canadian provinces, the implementation and applicability of the programs do differ, and I will be discussing those. So, as I mentioned, the addition of the Section 3 of the Quebec Charter was a significant addition and laid the groundwork for subsequent legislation which were aimed at promoting equality in employment. One of such legislations is the Act respecting equal access to employment in public bodies. This is the constituting act that governs and regulates equal access to employment programs in Quebec, and it was enacted in 2001. So this act specifically seeks to increase the representation of specific target groups in the workforce and to correct discriminatory practices within employment systems. In essence, it is designed to be non-discriminatory by focusing on correcting system imbalances rather than excluding groups from employment opportunities. So, as recently mentioned, these programs specifically target certain discriminated groups. In Quebec, this includes women, Indigenous peoples, visible minorities, ethnic minorities, and individuals with disabilities. Now, as an employer, if they're looking to implement or having to implement such a program, they have at their disposal what's referred to as a self-identification questionnaire. This is used by employers to implement such programs in their organizations or business. It allows for people who are applying for a job, or if they're already employed, to identify themselves as belonging to one or more of those target groups. These, as I mentioned, the groups are women, persons with disabilities, Indigenous peoples, visible minorities, and ethnic minorities. Now, the purpose of the self-identification questionnaire is to ensure equitable representation in employment of these discriminated groups. Because of this, the questionnaire in itself is not considered discriminatory. The information collected is also confidential and voluntary. However, it's not anonymous. So it means that while individuals are encouraged to provide this information, they're not required to do so. And if they decide to do so, their privacy is respected. So the adoption of the Act assisted in providing a structured approach to certain types of affirmative action programs. Now, as mentioned, all acts work in support of the Quebec Charter. And this interconnection between the two laws is clearly illustrated through the Charter's Section 20, which I recently discussed, and the Act's Section 14. Both sections address the concept of affirmative action programs and the promotion of equality, and they do so in a complementary manner. So as a reminder, Section 20 of the Charter was the provision which provided the exemption criteria to equality in employment. Implicitly, this Section 20 allows for the adoption and implementation of affirmative action program, as it recognizes that such measures are necessary to achieve substantial equality. Now, while we discussed special programs, and now I'm talking about equal access to employment programs, like I said, their objective is to promote equality and address systemic discrimination, but they do differ in their scope and implementation. Now, some key differences. Special programs, as Gillian mentioned, have a broader scope in that they address various sectors, while Quebec's affirmative action program focuses specifically on employment within public bodies. In this sense, special programs are mandatory for certain federal public organizations and federally regulated enterprises, whereas conversely in Quebec, they're only mandatory for specific enterprises, which I will discuss in the coming slides. They're also implemented through multiple departments and agencies at the federal level, whereas in Quebec, they're overseen by one governing body, similar to the other provinces. In this instance, it's the Human Rights Commission. Another substantial difference or notable difference between both programs is that the target groups. In the special programs, this includes women, Indigenous peoples, visible minorities, and persons with disabilities. In Quebec, ethnic minorities are also included. Therefore, while the mandatory implementation of these programs may be less frequent in Quebec, their scope is a bit broader in terms of their target. So there are 4 types of equal access to employment programs, or shall I say, 4 types that can be or must be implemented. Starting off, there are mandatory implementation of the program for public bodies. Next, there are also contractual obligations for companies to implement programs. There are also implementation of the program as a result of an investigation filed at the Commission or a judgment rendered by the Quebec Human Rights Tribunal. The last option is on a voluntary basis. Any type of organization can decide to voluntarily implement such a program. So, in terms of mandatory implementation of the programs, the Act respecting equal access to employment in public bodies applies to public bodies. But in terms of who is subject to the Act, it applies to public bodies that employ 100 or more persons for a continuous period of 6 months in each 2 consecutive years. Some examples of these would be municipalities, the education systems, health and social services network, crown corporations, intermunicipal police boards, and the Sûreté de Québec. However, it's important to note that simply because you are subject to the Act does not mean that you are necessarily required to implement an equal access to employment program. Public bodies who become subject to the Act based on their threshold of employment must analyze their workforce to determine if the numbers of employees in each target group for each type of occupation. They then must submit this workforce analysis to the Commission. The Commission will then review the submission, and in order to determine whether a target group is underrepresented, they will compare the representation of the group within the public body's workforce. If at that point it is determined that there is an underrepresentation in the public body, they will order the public body to establish an equal access to employment program. From this notice, the public body will have 12 months to submit their plan to the Commission for approval. Once it is approved, they will implement the plan, but their obligations don't necessarily end there. Following the implementation of the plan, the public body will have to report to the Commission on its progress every 3 years. They'll have to tell them the objectives met, the goals reached, and what they're planning on doing for the future. The second type of program which can be implemented is contractual obligations. So certain entities may be subject to a contractual requirement to implement affirmative action programs, particularly those that engage in contractual agreements with government bodies. So this includes private companies, nonprofit organizations, and other entities that enter into contracts with the government, whether it be through a bid or through a subsidy. There's a monetary threshold for this, as well as an employee threshold. So private companies that have more than 100 employees, as well as bidding for contracts that are over $100,000 or receiving a subsidy or grant from the government where the value is over $100,000. So there are some thresholds, some limits, but in essence, there can be contractual obligations as well. Now, entities that are subject to contract compliance requirements must develop and implement an affirmative action program that aligns with the standards which are set by the government in the Act. So although they're not subject to the Act, they must abide by the regulations provided for in the Act. Similarly, they'll have to conduct a workforce analysis and submit their plan to the Commission for approval. Now, in this instance, when you are contractually obligated and you fail to comply and you do not implement the program, it could lead to potential penalties, which most often would include a loss of a government contract or funding. The third way to adopt or to be asked to implement an equal access to employment program results from an investigation of the Commission or a decision from the Human Rights Tribunal. So because the Charter guarantees rights of the individual, it's possible that an individual can file a complaint for discrimination under the Charter to the Commission, and the Commission can then investigate this complaint and determine that there was in fact discrimination, and they can recommend or impose for the concerned authority to implement such an affirmative action program. If the employer then refuses, after the Commission has ordered or recommended or suggested for them to do so, The commission can then file an application to the Human Rights Tribunal to review, who will then render a final judgment, which could order the establishment to, or the employer or the concerned body, to have to implement that program. And in that situation, they will then have to submit their plan or their equal access to employment plan for approval to the Human Rights Tribunal instead of the commission. So you'll have more scrutiny and more oversight. So a notable case that I'd like to discuss about exactly a program that was asked to be implemented following an investigation is the case of the Commission versus Gaz Metro. So while the Commission has used this power very sparingly to recommend affirmative action programs or order affirmative action programs, this is a very notable decision, and it lasted 16 years. It was a 16-year legal battle, I guess you could say. So the case originated from a complaint which was filed by 7 women who were victims of systemic discrimination during the recruitment process for the position of network maintenance workers, which was a typical blue-collar work job exclusively held by men. In 1995, Gaz Metro signed a letter of agreement with the union, which would allow women and visible minorities preferential access to blue-collar jobs, and held a recruitment contest in which the complainants participated. In 1996, Action Travail des Femmes, for the purpose of this presentation, we'll refer to them as the female work group, filed a collective complaint on behalf of 8 women to the Commission based on systemic discrimination in hiring. Following its investigation in 2002, so we see 1996, the complaint was filed, the investigation was only finished in 2002, the Commission sided with the female work group and the complainants, recommending, in addition to damages, the implementation of an affirmative action program at Gaz Metro. However, in 2003, Gaz Metro refused to comply with the Commission's recommendations, which led the Commission to take the case, like I mentioned, to the Human Rights Tribunal. So from October 2004 to January 2007, there was evidence which was heard over 57 days involving 38 witnesses, 10 experts, many people were involved in this proceeding. Eventually, on September 11, 2008, the tribunal rendered its judgment and ordered the company to provide financial compensation to the complainants, as well as reinstatement, and adopt an affirmative action program. In 2008, the case was brought to the Court of Appeal. So Gaz Metro, although being ordered by the Human Rights Tribunal, applied to the Court of Appeal. 3 years later, in 2011, the Court of Appeal rendered its judgment, which upheld the Human Rights Tribunals. According to the Court of Appeal, the previous judgment was well-founded in law, and the conclusion of discrimination was largely proven. Gaz Metro at this stage decided not to appeal the judgment and committed finally to developing an affirmative action program in collaboration with the Commission. So in this instance, they had to work with the Commission to then file their plan to the Human Rights Tribunal for final approval. So we can see that although it's not something that's done often, the process can go all the way to the Court of Appeal. And at the end of the day, it can take many years to eventually implement such a program. Now, the final way to adopt or implement such a program is voluntarily. So for the provincially regulated enterprises that are not required or mandated to implement an equal access to employment program in connection with the 3 types that I have just discussed, they still have the option to do so voluntarily. However, if they choose to implement such programs, they have to follow the guidelines that are set by the Commission and the Act. The downside to the voluntary programs is that employers are not required to submit the Commission, their plans to the Commission for approval. So this lack of mandatory submission means that the information about these programs is not very readily available in Quebec. And we can see this because the requirement for approval is outlined in the first section of Section 87 of our Charter, which has never come into force. And this section is specifically targeted towards the voluntary enterprises, provincially regulated enterprises that would like or do implement voluntary equal access to employment programs. So consequently to this, the voluntary affirmative action programs and equal access to employment programs are very poorly documented in Quebec.
Thanks, Brooke. So if there are any questions, please feel free to submit them. We don't have a lot of time to get into them, but if we can, we will try and do so. In conclusion, as you've heard today, the current legal framework in the US and Canada applicable to DEI programs is significantly and substantively different. With respect to questions, we did receive a lot of questions in advance of the presentation today relating to organizations operating in both the US and Canada and how to navigate the different environments relating to DEI. That ultimately is a strategic issue and a business decision, and unfortunately not a question which we can generally answer here today. With that said, we would be happy to provide strategic advice to any of you who are faced with this question, which of course would take into consideration your organization's specific circumstances and considerations. With that said, what you can take from this presentation is that if your organization makes the business decision to continue or implement DEI programs in Canada, as long as they are bona fide and designed properly, you can do so with some comfort that in Canada, it's still legal to do so. With that, as I see no further questions at this point, and with time running out, I'm going to close off by just saying, first, you'll see information on your screen for CPD credits for Ontario, Quebec, and British Columbia. Links have also been added to the audience chat. If you don't get a chance to claim your certificate today, they'll be sent next week. Again, we'd appreciate if you could take a minute to fill out the survey as well. Our next LEHR webinar will be coming up in May. Please keep an eye on your inbox for the invitation. And if you have a chance, of course, we'd appreciate you filling out the survey for the feedback on our presentation. And thank you all for taking the time to attend today's webinar, and have a great rest of your day.